I'm going to turn it over to Judge Duane Benton to begin our presentation here.
Thank you. For those of you standing, there are chairs in the next room, and they're opening the area over here, so you can be over here instead of having to stand throughout the presentation, and a few scattered seats up here. Let me, sort of like President John, you didn't come to hear me either, but I will make a few quick, brief introductions so you know who's here. To my immediate left is Mark Levison. He's a partner at Lashley & Bear, past president of this association, by the way. He went as a BA and MA from George Washington, JD from Washington University Law School. For purposes of this, he was chair of Missouri Bar Committee in 2009 that recommended stricter rules on legal advertising. Next over is Terry B. Crouppen. He attended the University of Missouri. He then went to law school at Washington University School of Law, where he was on law review. He previously was a public defender in the 22nd Judicial Circuit. Next over is Ed Herman. He has many awards and honors as a trial attorney, trial advocacy. He went to the State University of New York at Buffalo, and then Washington University School of Law. Third at the end is Andy Crouppen. Mr. Crouppen went to college at the University of Wisconsin, then got his law degree at New York Law School. Of course, those three are with the law firm of Brown & Crouppen. Briefly, what we're going to do, Mr. Crouppen and Mr. Levison were given the option of adding other people. Mr. Levison declined to do that. They have agreed that Mr. Levison will present first. It's up to 10 minutes on the presentation, then Mr. Crouppen may respond. The last presentation will be by Mr. Crouppen because we'll have a summary at the end. That's up to 5 minutes. We hope to get to questions. I will attempt to rotate the questions between everyone that's here. I think that does it on ground rules, and I'll get out of the way, and Mr. Levison goes first.
Thank you, Judge Benton. Good afternoon, and I thank all of you for coming to listen to us today. To begin this conversation, it will be helpful to set the table with a little history. In 1977, the U.S. Supreme Court decided Bates and Osteen v. State Bar of Arizona. That case held that a blanket prohibition of certain standardized legal services was a violation of commercially protected free speech. Bates left many questions unanswered and noted that advertising by the legal profession posed special risks of deception. It held that the public lacks sophistication concerning legal services and that misstatements that might be overlooked or deemed unimportant in other advertising might be found inappropriate in legal advertising. At the time, Justice Powell forewarned that the Bates decision will affect profound changes in the practice of law, and he was right. Subsequent cases delved into various issues and various issues and types of lawyer advertising, and I've cited a number of those in our materials. Most of these advertisement cases reveal a lot of angst in the Supreme Court. The court's constantly trying to balance the rights of commercial speech and our profession's right to protect the public. Bates was a 5-4 decision. Many of these advertising decisions have been 5-4 or 6-3. In 1990, Chief Justice Burger warned about the dangers of lawyer advertising, stating, "A fringe of the profession seems bent on turning the practice of law into a trade or business like selling groceries, automobiles, or real estate. Because the law permits professionals to advertise, in no sense means it is proper to do so." But let's take a look at our experience here in Missouri. Each summer, the Board of Governors has a retreat. In 2003, we broke into 3 groups and discussed the issues we all felt were important. All 3 of the groups of the lawyers elected to represent the professionals around the state independently decided that the issue of lawyer advertising needed examination. I was tapped to chair that special committee, never expecting it was going to be a 6-year job. It was an imposing task, and I and the other members of the Board of Governors believed it was critical to appoint a diverse committee. We tried to get people from throughout the state, from different types of law practices, different ages, and we included advertising lawyers. The firm I worked at, Lathrop & Gage, advertised. We met for a long period of time. We studied the case law, what was happening in other states, drafted proposed rules, put them out for comments, and received comments and briefs. One brief was submitted by Thompson Coburn on behalf of Brown and Crouppen, another from Lewis and Rice on behalf of the Yellow Pages. After taking comments on our first draft, we rewrote the proposals and put out a second draft for comment. At one point, Brown and Crouppen presented the committee with 11 points it didn't like about the draft rules. Members of the committee met with Brown and Crouppen to talk about their specific concerns, and after hearing what they had to say, we agreed with about half of their concerns. We disagreed with about half of their concerns. I told Terry that we just didn't believe that clients ought to pick lawyers based on who had the best advertising agency. I will never, ever forget his reaction. He looked at me as if I'd struck him with lightning and said, "Mark, of course that's how clients should pick lawyers." And then he complained about lawyers being hired based upon recommendations from friends and relatives or other lawyers. This was kind of an aha moment for me because to put everything else in perspective, Terry and I weren't really having a discussion about specific rules on advertising. The discussion was about the soul of the profession. The difference of opinion between Terry and I is that I still cling to the idea that the legal profession is a calling and that we are all charged with acting in the best interest of our clients. Terry and others who think like him simply believe we are a business first, a profit center. I mean, look around the room. Lots of us have parents that were lawyers, kids that are becoming lawyers. What do we say to them? Do we tell them the key is making money or the key is serving your clients and doing good? What is our legacy going to be? So you know what, Terry and Ed and Andy may be fine people, but that's not the issue. They're not trial lawyers, and Missouri lawyers and judges know that. But in the past, they've represented themselves as trial lawyers to the public. Their locked and loaded commercial with them busting into the courthouse, guns a-blazing, in my opinion, was a good example of advertising used to fool the public. Remember the warning in Bates about the general public's lack of sophistication when it comes to legal services. If we could get that one little shot up there, Alex, from Esquire magazine. You know, Esquire magazine, you know, they singled out Brown and Crouppen as having one of the 5 worst attorney ads in the country. The Riverfront Times wrote, "Thank you, Brown and Crouppen. When it comes to unintentional, awful ads, you deliver a winner each and every time." And look, a little puffery in advertising is to be expected, but I challenge Terry and Ed and Andy right here and now sometime today to tell us how many cases they've each tried. They're business people, which is fine, but business people masquerading as trial lawyers is not a good thing for the profession or their clients, in my opinion. At any rate, eventually the rules that the committee proposed were endorsed by the Board of Governors. The Supreme Court adopted the proposed rules verbatim. Those rules have been enforced since 2006. The process took almost 3 years. A few years later, we thought there were some things that needed to be tweaked, and the committee was reconstituted. Because Terry had expressed so much interest in the process, I asked that he be allowed to serve on the committee or somebody from his firm. Tom Burke, then president of the bar, vetoed my recommendation. According to then Executive Director Keith Burks, only committee members on the special committee were allowed to meet and voice opinions. It had never happened before. He advised me we couldn't allow Terry into the special committee, but our committee was so hell-bent that everybody be heard that I overruled Keith, and Terry was allowed to participate in that committee. In 2006, the rules required conspicuous disclaimers in various contexts. The types of things that were adopted were fairly consistent with things that were going on in other states and amounted to moderate regulation of lawyer advertising, with some states being more stringent and others less. One obvious disclaimer was the statement that the choice of a lawyer is important and should not be based solely on advertising. When we went to tweak the rules in 2009, we added a definition of conspicuous. If we could get that Rule 472F up on the board. It says conspicuous means that the required disclosure must be of such a size, color, contrast, location, duration, cadence, audibility that the ordinary person can readily notice, read, hear, or understand it. The comments to that section state, if we could get that screen up, Alex, disclosures that are large in size are emphasized through a sharply contrasting color and, in the case of television advertisement, remain visible or audible for a sufficiently long duration, are likely to be more effective than those lacking such prominence. The disclosure should be prominent enough that the ordinary person will actually see and understand it in the context of the actual advertisement. So let's put up the brown Crouppen billboard currently located on Interstate 44 at Kings Highway, so you can judge for yourself if you believe this disclosure complies with the rules. In the materials I've handed out, there are other brown and Crouppen disclosures. So billboards are usually on highways where people are driving pretty fast, making it impossible to read small print. Brown Crouppen is not the only law firm that has this issue. Recently, Kaufman and Townsley billboards have appeared all around town, and here's an example of one of them from the handout. As people ride by their billboards, they don't even know there's anything in there by way of disclosure. It's actually there, but nobody would ever be able to read it. And Terry's response in respect to this particular issue in the past has generally been, well, what's the big deal? Well, it doesn't really matter what Terry or I think. The fact is, it's a rule that our Missouri Supreme Court requires. So somebody can say they don't like it or it's not effective, but particularly when you're a lawyer, you need to abide by the law or change it. Thanks.
Thank you. Yeah. Oh, okay.
Right on. I was speaking fast just in case.
If you believe everything Mark just said, Terry's an asshole. But like a lot of things Mark says, it's all bull, because Mark only tells part of the story. Let me go over just a few things. First of all, I'm Terry Crouppen. Hi, everybody. That's my son Andy and Ed Herman. They're both my partners. I didn't want to get into this. I didn't want to come here. You know, this stuff's over. You know, somebody said to me, you know, the advertising wars are kind of over, and the people won. He didn't win. I didn't win. The people won. They got good information. The rules are clear. The information has to be truthful and not misleading and honest, which we do, but Mark has trouble with those things. And let me point it out. I didn't want to go point by point. You just bring out the very worst in me. And now you grew a beard, which looks nice. I don't understand. Why do you do these things? The billboard, first of all, we're going to talk about the billboard we put up. I assume somebody's going to ask, but I did it for one reason. Mark initiated bar complaints against us last year. Last year. Out of the blue. You know, Mark wasn't really on my radar. I thought all this was over. He filed 2 bar complaints, which after, you know, they looked at it, you know, while he says, you know, it's no good, it doesn't meet the requirements, they looked at it, we were found, it was fine. No complaint. They dismissed it. So it's not really true when you say that it wasn't right. You know, the committee looked at it. We submitted it. You submitted it. They said there was no violation. Mark always tells me about this. He tells not me, because we don't talk, but he tells people like you. He tells Terry said that the best way to pick a lawyer is through an ad. Well, you know what? In the world he lives in, where I'm like a really bad guy, and my wife can tell you I'm really not, in that world, I would say something like that, being a villain. But I never said that. What I said to Mark, and we have some commercials, we could play them. What I said is, people choose lawyers for a lot of reasons. Because their brother-in-law went to high school with a lawyer. Because their cousin had a traffic ticket and a guy fixed it for him, and so they choose a lawyer. Because a lawyer happens to have an office near their house. And they sometimes choose a lawyer because they saw an ad. And all I ever said to Mark was, what's the difference? Why are we being singled out? I don't think getting a lawyer, there's no disclaimer. The choice of a lawyer is an important decision and should not be based solely on the fact that some guy got cheap rent near your house. There's no such thing. But they singled us out, and while I never said, and I don't know, I think Mark gets confused. I think he believes his stuff. But I never said that. All I said is there are a number of reasons to get a lawyer. This is one of them. It's not any worse. It's not any, I think it may be a little better than some, because they get to see you, they get to hear you, they look you up on the internet. But that wasn't ever said, and that's not how I believe. I just believe we shouldn't be singled out, unless everybody else gets singled out, unless they obtained a lawyer by some reason that Mark approves of. I don't believe that the law is a business first. But I believe there is a business component to it, as each and every one of you know. What we believe at Brown and Crouppen is we give the highest quality legal services available, I believe. We have lawyers sitting here. We have a lawyer sitting here who just got one of the big baby formula, the first time they've ever allowed inspections of the factory. She got that done for people that lost a baby. So what I believe is this. We are a profession, and we want to do great work because people come to us and need help, and we give it to them. But we want to help as many people as we can because it is a business. Yes, we make money off of this. But we're lucky because we get to make money and help people at the same time. So, yes, it is a business. I never said it's a business and nothing else. What I said, it is a business and it is a profession, and those things coexist. Another lie. Mark was the champion of letting us attend his committee meetings. Bull. Mark, after we said, we went to the president, Burke, and we said, we'd like to come to these meetings. We're members of the bar. Finally, we got it from Mark. Yes, you can come to the meeting. But do you guys remember what Mark said when we sat down? Yeah. You can come to the meeting, but you can't say anything. Well, of course, we ignored that, and Mark threatened to throw us out. Remember, you're going to get security to throw me out? And I said, well, you throw me out. Don't make security do it. But that's a lie. You know, he said you could come, but then he said you can't say anything. Mark says also, oh, this kills me when you say this stuff, about we don't comply. I'd like my son at some point today to go through Mark's history. I looked up last night what the word hypocrite means. That means somebody who says one thing and does something different. They got about 4 things over there that we could have filed bar complaints, but then I'd be a hypocrite because it's all bull anyway. But complaints about your website dating back how many years?
Many.
Where he didn't put the proper disclaimers.
Right through to the present day.
Yeah, and so don't give me this holier than thou bull. You don't follow your own rules, the rules you made up. You treat this disclaimer. Are there any Jews here? He treats this disclaimer like the Shema or the Lord's Prayer, when in fact I believe it's just an insult to the people in the state of Missouri, that they're too damn stupid to make up their minds how they're going to choose a lawyer. Because God forbid they may see an ad and they may think that guy knows what he's talking about. That guy has a good law firm. You know what? Who's got the thing? Let me play my ad. And you tell me, is this a better way or a worse way? Can we play it? Hello?
Yeah, he's got it right. Just
What do I do?
his books.
He's going to play it. Anyway, tell me if this is a better or worse way to pick a lawyer than the fact that some guy got rent near you.
I'm Terry Crouppen. Here's why you should choose my law firm, Brown and Crouppen. Our senior litigators are all members of the $1 Million Advocates Forum. We have 3 super lawyer honorees, and we've recently concluded a $40 million litigation against a major drug company. At almost 100 strong, we've been here for over 30 years, and we've been awarded the Better Business Bureau's highest A+ rating. Over the years, we've successfully represented more than 30,000 people. And to top it off, The editors of the Missouri Lawyers Weekly, one of our best-known legal publications, in 2011 named our chief of litigation one of Missouri's winningest plaintiffs' lawyers. And more important, they went on to name Brown and Crouppen Missouri's winningest plaintiffs' law firm. If you need help, these are the reasons to choose Brown and Crouppen, and you can call us anytime for free at 222-2222.
Thank you. Yeah, here's the deal. That's not a bad way to choose a lawyer. Certainly as good as a guy who fixed your cousin's ticket. And you know what, Mark? There is not a single misstatement, lie, untruth, half-truth in any word I said. And if there is, I'll take it down and apologize to you. It's not like everything you've said since you got up here. You know, here's the deal. We are facing national law firms. We're facing, first of all, the internet. I am a dinosaur when it comes to the internet. Those guys know about the internet. The internet is where marketing is going. We spend more on the internet now than we do on television. The rules that he would like to restrict each and every one of us with make it very difficult, and Ed, if you want to ask a question, Ed and Andy will explain why, make it very difficult to compete with lawyers out of state for cases. They're coming into our state, taking our business, and it's only going to get worse. Do you know a guy named David Middleman, Mark? No, I wouldn't expect you would. David Middleman's going to spend $42 million this year on national buys. They're going to take cases from each one of you. Take them from us. Do you know a guy named Finkelstein, Andy Finkelstein? No, you don't know that. Andy Finkelstein is now in the works of fighting the laws in the state of New York to bring a national law firm into existence. A national law firm. And I hate to shake your tree, some of you guys that don't do PI, Social Security, mass tort. But once these guys get funded with big money, hedge fund money, they're going to come after not only us, but they're going to come after all of you, because business law is profitable.
And that's 10 minutes.
Okay, great. So anyway, thank you. Nice meeting you. Good presentation, Mark.
Yeah. At this point, we'll have questions. Mr. Levison will have the first question. I'll attempt to rotate the questions. Someone with a question for Mr. Levison first. In the back. Go ahead. Stand up if you would, so I can hear you.
I have a question. Really, this whole thing seems like there's a lot of personal stuff that I'm not really sure the point. How as lawyers, we address this issue of the constitutionality of commercial speech? It seems to me, as a lawyer, whether you like advertising or you don't like advertising, we'd all be lining up for any other industry, profession, be it, clergy. And I can't imagine seeing a billboard, don't choose this religion based on any advertising, or any plumbers don't base choosing a plumber based upon, or past results may not be typical. I just kind of feel that it just seems most of, anecdotally, the attorneys that I know are in it to be a lawyer first, and the business hopefully comes second. But the thing that we all really seem to really care about is the Constitution.
So we get it going. Mark, go ahead.
Well, yeah, the issue of free speech is an important one. And Terry, quite often in the debates I've had with him, wraps himself a little bit in the flag and says it's all about free speech, but really it's not. It's about Terry getting business. He's not Patrick Henry. You know, free speech, I think it was Justice Holmes that first said, you know, there's not absolute free speech. You can't yell fire in a movie theater. And the court has struggled with these issues in Board of Pharmacy, Virginia Board of Pharmacy. They first started giving more protection to commercial speech. And in the Central Hudson case, which I've cited in the materials, there's a 4-part test. So it's always a balancing issue. But, you know, commercial speech obviously has its bounds, and you don't want to be deceptive. it's up, as I said, the court has really struggled with this, but it's a trend all across the country to regulate lawyer advertising for some of the same reasons that Justice Berger talked about.
Yeah, I just, again, Mark, either you don't know what you're talking about or you don't keep up on stuff. The trend in the country is to follow the ABA rules, which are very, very much limited to false and misleading. The state of Florida, which used to have very restrictive, the court struck down their restrictions. Virginia actually has some of the most liberal. They were struck down. In Iowa, which you couldn't advertise, they had no advertising. Now you can advertise. So again, the trend is to, ease restrictions on the idea that this is free speech. And I don't wrap myself in anything, except my wife occasionally. But I don't wrap myself in anything. I respect. We got about 3 or 4 Brown and Crouppen lawyers. We've got guys that, men and women, I'm sorry, I can't use that guys anymore. We have men and women that's all they care about. They do a wonderful job. They're great lawyers. And do I care about anything but money? Yeah. I care about, my children, what they think of me, my friends and family. I try to do nothing to insult that. We do a good job. Yeah, we make good money. I got no complaints. But you're not doing it for free either, so. That's it.
And that's time. Okay, now, question for Mr. Crouppen. That's a question, Mr. Crouppen. Go ahead. Say it again.
How do you think advertising has affected professionalism for attorneys?
I think it's several years ago we had a meeting, and one of Mark's buddies, who wrote all their stuff, gets up, and we're talking about advertising and how the truth of advertising is it creates more business for us, more cases, more people, because not that they're not good cases, it just explains to people that never knew. 90% of the people, well, maybe not 90, 60% of the people we represent have never had an idea that they could do something about what happened. So you got to remember, the cases that are created by advertising are not bogus cases. They're legitimate cases that people just didn't know about and would have never known about. Our mass tort business, where we, and I keep using the word business because Mark's going to jump on that, but frankly, it's a business, it's a profession. I'll use the word business. I'm not going to change. They wouldn't have known that these the problems they were having in their abdomen were because of mesh. They wouldn't have known about Vioxx. We make the pool of cases bigger. And from a business point of view, if I was only about business, I'd say, my God, I'm making all these extra cases, and a lot of you are getting them. We don't get all of them. But it makes more cases for everybody, and they're legitimate cases. And professionalism means really not a lot. We do everything professional, whether we have one case to work on or 1,000 cases to work on. We have ask about Jim Lemons, what kind of lawyer he is. Jimmy Cantlin, Andrea McNair, ask what kind of lawyers they are. So it doesn't affect professionalism with us. We take the cases and we help the people.
Mr. Levison, 2 minutes.
Well, sure. Why don't we run that video that I brought? It's the ad that we mentioned earlier.
These aren't actors. These are real Brown and Crouppen lawyers.
Eddie, are the witnesses here?
Boss, they're looking good and raring to go.
Andy, what about the exhibits?
Locked and loaded, Dad.
Cell phones off?
Going to be a rough day for the insurance company.
But a good one for the good guys. Boys, let's make them pay.
Brown and Crouppen. Muscle, talent, results, and a no-fee guarantee. Call 421-HELP.
So when we talk about how professionalism has been influenced by the advertising. There's an example. You know, when Terry first campaigned against me, he handed out little flyers at the courthouse, and one of our well-known St. Louis judges suggested that I'd done something nobody else in St. Louis had ever been able to do, and that's get Terry Crouppen to the courthouse. You know, so as we look at this ad, it's offensive to trial lawyers. It's laughable to those of us who know the guys who are posing as trial lawyers, but more importantly, it really is deceptive to clients. That's my opinion. And those types of ads, I don't think, put the profession in the right place. It takes us in the wrong place. I have said time and time again, it's good to let those folks who don't know they can hire lawyers have the information that they can hire lawyers to redress their wrongs. That doesn't mean we have to be deceptive.
Can I say something?
Sure, go ahead.
First of all, Mark, I've done something you've never done. I have created and founded a successful law firm myself. Yeah, do I try the cases? No. Does Lee Iacocca build the cars? No. I created it, I hired it, I staffed it, I funded it. I brought in cases for some of the finest lawyers in this state to work on. So when I say, are we ready to go? Symbolically, I'm the head of the law firm. Symbolically, my son and Ed Herman, we run the law firm. So what's deceptive about that? When Lee Iacocca gets on, or any of the people that are the president, or when Steve Jobs, you think he builds the computers? No. When he was alive, he didn't. He was just the creative mind behind it. He was the head. He created it. So that's not deceptive, frankly. If I was going to get a lawyer, what did that commercial show? You laugh a little bit. I think we've had almost 200,000 hits on YouTube on it.
And it was designed to be funny. It was
But it's symbolic. What kind of lawyer you want, Mark? You want a guy that's afraid to go and isn't going to fight for you? You know, you notice we pushed into the light. You know, I think people want a champion. That's what every one of you should be, and I assume you are. You're a champion for people that don't know how to help themselves, and they come to you to be their champion, to fight for them. And I think, while we laugh, the public doesn't laugh. The public says, I want somebody who's going to fight for me. I want somebody who's prepared. I want somebody who's not afraid. I want somebody who's going to win for us. If you think that's, I don't know what you guys do over there, but I'm guessing, yeah, go ahead.
Sure, go ahead.
Your time, but just because I take this a little bit personal, I've tried cases, and I participate actively in all the litigation, and as well as Andy, that goes on in our law firm. When I was in the early part of my legal career, even coming out of law school, when Mark was president of the Lawyers Association of St. Louis, I was awarded the Milton Napier Award for trial advocacy. When I graduated law school, I was given the William Pomerantz Award for trial advocacy. I was given the Lewis F. Powell Award for trial advocacy. I was voted by my peers at Washington University as the person that they would hire if their life was on the line and they were on trial for murder. Joe Yeckel, you were in that class, you probably remember that. So I don't personally like having my credentials as a trial attorney attacked. I think anybody in this room that's ever worked with me would feel very, very comfortable having me represent them in court. Well, sure. Look, Terry's words were right. The public doesn't laugh at this. And if you believe what he said, that this was put up as a joke, then believe everything else he's saying. There was no joke about that ad. It was designed to suck in people to come to their law firm. And the fact is, if you talk to people in the community and you talk about Terry Crouppen, even some lawyers at times, they have no idea that these folks aren't the ones trying the cases. If your ad would say, look, Terry, Ed, and Andy, we run the business, we don't try cases, but we hire some lawyers that try cases, that might be okay.
Ooh, the germ of another disclaimer, Mark.
Terry, you're always interrupting. You see, all right. So since he was interrupted, I will point out that what he said about the special committee, we allowed Terry to come into the committee and talk Then when we deliberated, he was not allowed to talk. That's what happened, and he couldn't stop himself. So there were times when we had to threaten to leave him. So that's what you've seen is this personal interruption. And it,
Please.
Going into that, would you address why you file bar complaints for us not complying with the disclaimer rules, but then neglect to use the disclaimers on your own websites?
I will gladly talk about
Good.
bar complaints.
Could everyone hear the question?
That's not working. There you go.
As the chair of the Special Committee on Lawyer Advertising, there is an obligation that some of us have to report problems they see. There was a point a few years ago where it seemed to me the billboards Terry and others were running violated the rules. So I filed a report, not a complaint. Terry doesn't understand the law on that, but I filed a report, and OCDC decided it was worth a complaint, so they issued a complaint. Now, this bit about websites of law firms I'm in, if they want to file complaints, let them file complaints, because words don't mean anything, actions mean
So
something.
you're saying that you shouldn't put the disclaimers on until we file complaints to force you to use the disclaimers that you wrote?
There is no website that I know of that I'm involved in that violates the rules. That's all I can
If
tell
I
you.
have printouts of them, currently your profile page at Lashley Bear, your current firm, past results, no disclaimer. There is a current FindLaw profile of you, past results, no disclaimer. There is a website that is no longer up, the Levison Group, past results, no disclaimer. There is a previous website of you, your Lathrop Gage page, past results, no disclaimer, a disclaimer which you wrote.
Like I say, the law firms I've been in all have the disclaimers. He can say that. If he wants to make a complaint, let him file.
Anyone who has a smartphone, why don't you look up Lashley Bear's website, go to Mark's page, see if there are past results, and see if there's a disclaimer. Or, I printed it out for you. I have 40 copies. Anyone who would like one can come up, and I will hand it out to you.
Okay, let's go to another question. This is a question addressed first to Mark. Go ahead. Stand up, please.
Mark, it appears that you present a false choice, and that's what I'm taking issue with. I know a lot of attorneys over the years who are good attorneys, but they're bad business people, and as a result, they fail. And I know people who are good business people, but bad attorneys, and they fail. But it seems like what you're saying is if you're advertising, you're a business person, and to be a good attorney, you can't advertise. I think it's a false choice. Why can't you do both? I mean, you really have to have both in order to succeed in our practice and do well for your clients. It seems like you're saying it's one or the other. I think it's great to be idealistic, but you also have to be practical too, or you will not succeed in our profession.
Of course you have to be practical, and I'm certainly have never said there should not be advertising. On the advertising committee, it was a very diverse committee. There were some folks who really didn't believe there should be any advertising, and there was others, many advertising lawyers. We tried to strike a middle road, and we think that's what we did. And keep in mind, the advertising rules were passed by the entire Board of Governors, suggested, that's 45 of us, and the 7 members of the Supreme Court unanimously adopted verbatim those rules. So those are the rules in the state of Missouri. They just ought to be followed.
We agree.
Yeah, we follow them, Mark, as you well know. And they're just going back, and I said it before, but I'm not going to file a complaint for some technical violation, even though if you do, because then I'm a hypocrite, and I don't want to be a hypocrite. If whether you put past disclaimers, that past disclaimer, it doesn't make a difference, as most of these things don't. So I'm not going to file a claim against you, but let people know. When you pass rules, and because you were the head of the special committee, you think you don't have to follow them, and you're never aware of anything. That's what I love about you. Now that you're aware, you want to change anything you said, Mark? you know, that you put the things up, and while you weren't aware, now you're aware that you're not in compliance? Do you want to, because of your position as head of the special committee, you want to tell them how you're going to file the complaints and turn yourself in, like you turn everybody else in? I mean, do you think, I think logically that would be the way to go.
Look, the record speaks for itself.
It
We
does,
always have these
exactly.
personal attacks in this when we really need to be talking about the bigger issues. Where are we going in this profession? Are we going to a business model? Does business come first, or is it a calling? That's the real issues here going forward.
Mark, would you take a look at the websites I handed you and see if you feel as though those do require the past results disclaimers?
Well, of course they do.
And would you also look and let me know if those are there?
My understanding, because I checked before I came here, is that the Lashley Bear website has all the necessary disclaimers because I asked them.
They're
That's my
incorrect.
understanding. Well, they may be
Did you-
incorrect.
did-
I don't
can
know.
I- did
Like
you
I
look-
say, if it's wrong, make a complaint.
Do you have internet access? Did you look and see if they were there?
What is the point even if somebody out there has a violation, does that mean you guys
No,
are
no,
right?
Mark, what it means is if you made a mistake and you did what you turn everybody else in for, if you go after the meeting and look and you've done the same violation, the same type that you accuse us and other people, are you going to turn yourself in? That's all I want to know.
If I find...
Will you turn your, yes, if you, my hypothetical is you look, we're right, you're wrong, you violated the rules, are you going to turn yourself in like you tried to turn us in?
I will gladly look at the Lashley Bear website, and if it's determined additional disclaimers need to be put on, I'll tell them to do it.
But do you think it's a problem? Sorry.
You didn't give us that option, Mark.
Let's go to the crowd for a question for Mr. Crouppen. Go ahead. Question for Mr. Crouppen.
Probably the oldest lawyer in this room. Been practicing for 63 years. What I'm a little bit disappointed in, it sounds like they got some lawyers who are acting like a bunch of kids. I'm getting out of it.
Is that if that's a question, A, you look wonderful, and B, you're absolutely right. I didn't want to come here. I don't want to argue about this stuff again. We've done it over and over again. And you just bring out the worst in me, Mark, and so I apologize for that. So I'm sorry we drove this poor man out of them. After 63 years, we had him throw up his hand.
Well, you know,
So
but I
that's
think he brings up an important point, and the problem is, you know, in this forum, it does look like that. But the reality is when these rules are passed and when these committees get together, one of the committee's suggestions initially that probably would have been passed had we not really gotten involved was they wanted to essentially eliminate all television advertisements. And the way they were going to do that is they were going to require an oral disclaimer, not once, but twice within a commercial. So it was about 14 or 15 seconds, if not more, of disclaimers orally in a 30-second commercial. So the reason we get so passionate about it is because that destroys our livelihood. And so I think any one of us, if there was someone out there who was trying to shut your business down, I think you would defend it as passionately as we are. And I apologize as well that it comes across sometimes as childish, but, you know.
Let's let Mark respond. About a minute.
Yeah, we were really trying hard in the advertising committee to get it right. That's why we put out rules for comment, and we listened to people. And Andy is right about that one thing, that they complained that the disclosures that had originally been proposed would be too long and would be too difficult for advertising, so we changed them.
You know what? For us to go back and forth about what happened, the way you're portraying it is inaccurate. We were there. There's a guy named James Thompson from Edelman and Thompson who was on the committee. If any of you really want to know how these meetings went and the fairness that Mark used in these meetings, contact James Thompson. He can tell you exactly. He was on the committee.
Or you can go to the website anyoneButMark.com and read the whole story of exactly what happened.
That's anyoneButMark.com.
Let me break in. To keep us halfway on time, we better go to the closing statements. Mr. Levison's going to go first on that. He's up to 5 minutes, and then Mr. Crouppen ends.
Well, that time goes by fast. It's been an honor to serve my fellow lawyers, first as President BAMSL, then as President of the Lawyers Association, and now as the longest-serving governor in the history of the Missouri Bar. I'm really humbled by my fellow lawyers electing me 10 different times to that office. And most of us agree there's a proper place for lawyer advertising, and most of us who've looked closely at today's advertising would also agree that the current rules are not being followed. It makes a mockery of the bar, of our Supreme Court. It harms the good lawyers, and even more importantly, it harms the citizens who often get poor service from lawyers only interested in money rather than professional services. In my opinion, the locked and loaded type of advertisement Brown and Crouppen often offers takes the profession in a wrong direction. Terry tells the public he's a practicing lawyer, but what he really is a practicing pitchman. Many lawyer advertisements prey on the poor and the uneducated. When I was leading the Special Committee on Lawyer Advertising back in 2005, Terry decided he wanted to run people for the Board of Governors against me, and I applauded him for that. It's our democratic process. Ed and Andy and one other Brown and Crouppen employee ran it in that election. They lost, and the three of them all together got about half the votes I received. The person who got the lowest vote in the race, perhaps in the history of the district, was Andy. He got only 141 votes, and I suggest it's because his name was Crouppen. That's because the vast majority of lawyers in our community stand for different things than Brown and Crouppen. In 2010, I filed a report asking the OCDC to look into whether a complaint should be filed. They filed it. Terry reacted by having Jim Lemons, who had just joined Brown and Crouppen, run against me. Fortunately, all of you elected me with about double Jim's votes. Unfortunately, perhaps because our fellow lawyers are just not inclined to elect folks from Brown and Crouppen, they tried another tactic, and Terry launched the first negative campaign in Missouri bar history when he handed out negative flyers at the courthouse and went on radio campaigning against me. This was the flyer he handed out. But that's good. It's good to get attention to Board of Governors elections. Then last year, he raised the stakes by paying for a negative glow-in-the-dark billboard. But you know, neither I nor I doubt any of you out there will be intimidated by bullying when it comes to defending our profession. I'm very comfortable standing on a different side than Brown and Crouppen on issues of professionalism, ethics, and lawyer advertising. I am personally a big believer in free speech. I'm not a big believer of negative campaigning in any campaign, but to each his own. When Terry first ran his billboard, I went on KMOX and said it was Brown and Crouppen that did it, but they didn't put their name on it, and I suggested negative campaigning without identification of the source seemed a little cowardly. I think it was the next day that his name went up on the billboard. You know, in the Wentford case, I've cited that in the materials. It's the most recent Supreme Court case I've given you. Sandra Day O'Connor wrote, Bates was an early experiment with the doctrine of commercial speech, and it has proved to be problematic in its application. She added both the special privileges incident to membership in the profession and the advantages those privileges give in the necessary task of earning a living are means to a goal that transcends the accumulation of wealth. That goal is public service. She writes, restrictions on advertising serve the same goal. Such restrictions act as a concrete, day-to-day reminder to the practicing attorney of why it is improper for any member of this profession to regard it as a trade or occupation like any other. So what is troubling is our move away from a calling towards a business model. I, for one, will never surrender to the belief that business comes first, dedicated service ought to come first. But who's to blame for this situation we find our profession in? We can't simply blame the Brown and Crouppen mentality. They just don't see things the way most of us do. The mission behind their business is making money, and we are probably not going to convince them about the nobility of the law. The people to blame is us. It's you and me. The people to blame are those of us who believe we are charged with something more important than only making money, but who don't do anything about it. Certainly, lawyer advertising is part of the issue. There are advertisements all over the state that violate our Supreme Court rules. It is a very simple thing for those of you out there to send a letter to OCDC asking them to look into any issue you believe may violate the rules. And we need to get across to the new lawyers that it doesn't have to be this way. We can put professionalism above economic interest. We need to lead by example. So let's end where it began with Bates and the Supreme Court admonition in Bates, and I quote, "If the naivety of the public will cause advertising by attorneys to be misleading, then it is the bar's role to assure that the populace is sufficiently informed to enable it to place advertising in its proper perspective. We suspect that most lawyers will behave as they have always have. They will abide by their solemn oath to uphold the integrity and honor of their profession and of the legal system. For every attorney who overreaches through advertising, there will be thousands of others who will be candid and honest and straightforward. And of course, it will be in the latter's interest, as in other cases of misconduct at the bar, to assist in weeding out those few who abuse the trust." You know, the sound bites of today's debate may be about lawyer advertising, but the importance of this debate is our internal consideration of who we are and where we are going. Thanks. Thanks for listening to us.
We have 6 minutes.
Thank you. I don't know. I don't know where to begin. What do you know about the public? We've represented 30 or 40,000 people. How many people you represented, Mark? You know, I'll say it again. Each and every client that we bring in the office, you know, none of the complaints that Mark ever files are about we didn't do a good job. They're always about some crazy, you know, we didn't have something big enough. File the complaints. Here's the OCDC, maybe you never saw it, of their opinion of what your complaints amounted to. Nothing. We follow the laws. We follow the rules, your rules, as stupid as some of them are. When we had the bar, your committee, you received briefs from our letters from the ACLU, Public Citizen, the NAACP, the Federal Trade Commission, and the American Bar Association, all on our side, Mark, not on yours. You know, it just gets me angry that you come in here. If you have clients of ours, if you think we haven't been professional, then bring them forward. Sue us, file complaints. Lord knows you know how to do that. And let's just have it out. But this kind of, you know, each and every one of you, what they want to do, when my son brought up this disclaimer, they actually wanted to have a disclaimer. We're in a 30-second commercial on television, and a lot of times we use less than that. 15 seconds. We had to say the disclaimer, the choice of a lawyer, et cetera, et cetera. We had to say it twice, slowly. Now, is that what kind of protection is that? Saying a grown person, don't choose a lawyer because you see an ad. How is that really protecting anybody? You know how you protect us? You know how you protect the profession, Mark? Go and find out when lawyers are doing bad jobs and aren't helping their clients, and sue the lawyers that didn't do the good job, if you know how to do that. I'm not sure what you do. You know, you don't follow your own rules. You call other people on it. I don't know. You want these people to follow you. I don't want you all to follow me. I'm not your leader. I'm not your hero. I'm just a guy that believes what I'm doing is the right way for me. But I wouldn't follow a guy that, you know, I'll tell you, I did the billboard and the handouts for one reason. You're, unfortunately, my bar representative. And I didn't want a liar and a hypocrite representing me. And that's what you've demonstrated to me over and over again who you are. And so, that's why I did it. I did it not for you, but for me. I didn't want a person like this being my representative. And that's the honest truth. Go home, file all the bar complaints you want, because I think, as Mark suggests, that's where your energies should lie, trying to police people from giving honest information to the public. I'm going to keep doing it. We think we're doing right. The Missouri Bar thinks we're doing right. And you, fight it. Good luck. Hey, everybody, thank you so much for listening.
Okay, that ends it. Please give our, and it's lunchtime.